Hello, good evening, welcome all today. We have here with us Mr. Vikram Nankani to speak on PMLA, which half of us don't know what it is. And we are here for that. 1 minute, I'll just pass this to our president to give a welcome speech.
I have great pleasure in welcoming Vikram, who is a senior counsel, ex-partner of ELP, who agreed on a single phone call immediately to come and give this lecture. I am extremely grateful to him, and I am sure you all will take away a lot from this lecture. So I will not say any further except to say thank you, Vikram.
Thank you, Farzana. Thank you, Nilesh, for having me over. Thank you. I think I'm entering this room after almost 40 years because came here, I had signed Farzana in the short introduction. She should have mentioned the most crucial thing, that we were colleagues at Vadya Gandhi. I was there as an article clerk with Mr. Sept, and that was in 83, 84 that I came here as one of the students in this room to hear some lecture. I can't remember who it was, but there was something on conveyance, which was, and Moshe Setna told me, you have to go and you have to attend. Of course, he was horrified when I didn't ultimately sit for the exam. I signed my articles and didn't sit for the exam, and that day I was really given an earful. But so glad to be back here, and sorry for the delay, but let's get on with the subject. Nilesh actually made a very threatening start by saying 50% of us don't know. I'm worried about the 50% who know. And those 50% are the ones I'm waiting to be grilled by. So, as the name suggests, I mean, there's nothing so threatening about the subject, Prevention of Money Laundering Act. Day in and day out, we all use the word laundry, send your clothes for laundry. This is precisely what is being suggested or being done with the money. So you send bad money or soiled money or tainted money, you send it out. How do you launder it into white money? And that is where the law steps in to say that we are going to prevent laundering of tainted money. And in the popular sense, you could say unaccounted money, because that's the popular expression that we all understand. Black money, unaccounted money. These are words which we use in day-to-day life. So tainted money, when it is being laundered, it is called money laundering. And world over today, globally, because of certain particular offenses like terrorism, drug money, arms, it is called as anti-money laundering law. So you would wonder that if somebody wants to launder something good, when I send my clothes to the laundry for washing them, it's something good. But in the context of money, it is just the opposite. So you want to prevent money laundering from happening, and that's why world over there is an organization called as FATF, and this is the task force which has been formed at a global level to ensure that jurisdictions, particularly tax havens, which you would have popularly heard of, like Cayman Islands, BVI, Luxembourg, these are tax havens where there are no regulatory rules in place, and money can just freely flow in and flow out without any questions being asked. So FATF is a global body which was formed to take care of anti-money laundering all over the world, and India, of course, being a part of that global community, had to sign that convention, so that it is emanating out of the Vienna Convention. And what I'm telling you is not something of my own. If you read a judgment of the Supreme Court called Vijay Madanlal Chaudhary, a 3-judge judgment of 2022, you will get the entire historical background as to how and why this legislation was put in place. Curiously, the legislation was passed on 1st of July 2003, but that is when it received the assent of the President. But it was notified or brought into effect from 1st of July 2005, if I'm not mistaken. So it was in 2 years, it was in hibernation. but it was given live on 1st of July 2005. So that is what the statements of objects and reasons say, that it is to prevent money laundering. Now, typically, without getting into the definition of what money laundering means, which I will come to a little later, three things which is for simpler understanding of the law. When you read the law, you again find all the technical jargon. Essentially, money laundering, when I say it is to convert tainted money into untainted money, it involves three steps. First is the placement of the money. That you place the money, you move it from the scene of offense and try and remove the money away from the offense. So that is placement. The second is layering. You layer the money in such a way that nobody can trace its origin, that where does the origin come from. And thirdly is the integration of that money into the normal economy, the mainstream economy. And these three acts, placement, then layering and integration together, sum total of these three constitutes money laundering. Now, you will not find these three words in the statute book in section 3. You will not find them. But let me give you a very simple example. On a day-to-day basis, what you will see. And maybe that's one of the live cases that we are doing. So you have a company which purchased stocks of a listed entity. The stock was being quoted below par. Mir will immediately give you multiple such examples. So the stock is quoted below par at 3 rupees or 4 rupees. You then become a member of that company by subscribing to the shares of the company which holds the listed shares, listed company's entity bought at a very cheap price. You then become a shareholder of this company which is holding those shares. Suddenly the share starts moving 100 times, 200 times. Then it is sold on the stock market. The money comes into the company, distributed as dividends, and you have received the dividends, which is the white income. So the placement, the layering and integration. Now, how has this happened? You dissect this transaction where the company X is holding the shares of a listed entity Y. It is predetermined that you will manipulate the price of the share from 3 rupees to, let's say, 300 rupees, which is 100 times. The person who is going to be acquiring the shares of this company X knows this in advance. So he has got some unaccounted money. He's got cash sitting at home, which he wants to convert into white money and bring it within the mainstream system. So he approaches the promoters of company X and says, I will give you cash, 200 rupees, I will give you cash. So he actually pays cash of 200 because that's the unaccounted money that he has got, tainted money. He then pays 3 rupees, which is the face value of, or 10 rupees for the shares of company X. He acquires that, whatever the number of shares that he wants to acquire, and he's paid 300. So his cost of acquisition, let us say, is 250 rupees. Because 50 rupees he bought shares of face value of 10 and he has paid 200 cash. Ultimately, the shares, which is an asset of this company X, it's an asset of a listed company, which is nothing to do with this company X. It's an unrelated entity. This company X then dumps those shares in the market after it has gone up to 300 rupees. How it has gone up to 300 is the manipulation, the rigging that happens of the price. It is sold in the open market. So then that is how it is layered by. It is layered by buying the shares of a listed company at 3 rupees, sold at 300 rupees. 300 rupees comes into as the sale proceeds to company X. Company X then distributes the profits to its shareholders by way of a dividend, and that's purely within the discretion of the company. So what does the shareholder do? What has he done? He has placed his black money first, which is the offending part. He then has layered it by putting that money, by acquiring the shares of this company X at 10 rupees at face value. On the strength of the asset of this company, he now will integrate his money. So when he receives 300 rupees as dividend from company X, that is his white money. So he's converted his cash into white money. You can multiply this example in various other scenarios. Take in the context of terrorism, drug money, etc. It happens through diamonds, and you buy and sell diamonds by actually getting bills where really there is no underlying transaction of transfer of property in the goods. It's just billing that happens. You show that you have purchased the diamond, paid this amount, then show that you have resold the diamond at a 10x price. 10x, the delta of x and 10x becomes your profit, which is the layering that you have done. Now, if this is what it is, can we go to section 3? And you see, it says, whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party and is actually involved in the process or activity connected with the proceeds of crime. I will come back to what proceeds of crime mean, and that will, because that's a different topic altogether, and projects it as untainted property. Projects it as untainted property. Now, let me take another example. A government servant is bribed. The bribe giver gives him bribe in whatever form. It could be in the form of cash, it could be in the form of gifts, it could be in the form of shares, it could be payment being made to a third party for and on behalf of the public servant. So again, to use a very typical example, that money is paid in a foreign bank account, which is controlled, which is in the hands of a third party. So the money moves. Now what is this money for? It's a bribe. So it is the property which is being placed into the hands of a third party on behalf of the public servant, government servant. This money which is lying in a foreign account now needs to get integrated and laundered and projected as untainted money into India. So what that person will do, in whose account it is lying, he will enter into a transaction with the public servant. What will the public servant sell? He or his wife or his son or brother. It's not necessarily that it's only the public servant. It could be even a legal entity controlled by the family members of the public servant. They could, for example, show a plot of land at Lonavala or Khandala, which they have bought at a very cheap price. Why? Because they've paid cash for that. So they've bought it at a very cheap price. And this bribe money which is sitting outside in an account in Dubai or Switzerland or wherever, that money will be used to acquire this plot again at 100 times the original price or the document value, which is the actual market price, or maybe even more than the market price. So the land is then acquired by the public servant, land is sold by the public servant. He then gets the entire money from this person sitting outside of India, as if he has acquired this land from the public servant at 100 times the original value. So the public servant has then got money which is projected as an untainted property. If he's asked tomorrow, how did you get this 10 crores? He'll say, this is the plot of land that I sold. How much did you buy it for? Oh, I bought it for 20 lakhs. But so what? I bought it 3 years ago. Market price has gone up. Why? Because there is a coastal road coming next to it. There is a tunnel coming next to it. Market value has gone up. There was a desperate buyer. He sold it to me for 10 crores. As long as you offer it for tax to the income tax authorities and say, okay, fine, I have made capital gains on this. Tax me on capital gains, which is 10% in the long term or 20% in the long term. He pays tax, and at least he enjoys the remaining 8 crores for the rest of his life. So the bribe which was paid to him outside of India to a third party then gets projected as a untainted property in the hands of the public servant. Indian mind is ingenious. Why Indian mind? Why we should not bash only Indians. Even these kind of transactions even happen outside of India. The human brain is ingenious, and they come up with this kind of transaction. Now, while I gave you this example, you got distracted because you did not focus on the definition of the offense under section 3. Who is the person who is here guilty of money laundering? The person who is sitting abroad who received the bribe money, or the public servant who is in India? It is the person staying outside of India who received the money. He is the money launderer. He is guilty of an offence under section 3 of money laundering. Why? Because he is the person who knowingly receives this money, who knowingly is sending that money back to the beneficiary, knowing fully well that the land that he is buying is not worth 10 crores, and projecting it as 10 crores. I mean, if I change, instead of the land, if I substitute it with an asset called painting, some of you would immediately understand which is the transaction I am talking about. It was widely reported in the papers few years back. The chairman of a bank was arrested for that transaction, and so you bought a painting. To you, beauty lies in the perceiver's eye. You may think that the painting is just a piece of paper, not worth even more than some pittance of an amount, but the seller and the buyer thinks that it's so beautiful that it's going to appreciate in the next 5 years. So let me buy it at 100 times or 200 times. So that is the person who is assisting. The public servant is already committed an offence under the Prevention of Corruption Act. He is guilty of the offence of accepting illegal gratification under section 7, read with 12 and 13 of the Prevention of Corruption Act. So he is not the target under section 3. In section 3, the person who knowingly, if you see, indulges or knowingly assists or is knowingly a party to what? To concealing, possession, acquisition or use and projecting them to be as untainted property, the proceeds of crime, if he says. So what is the proceeds of crime? The bribe money. Who has assisted and knowingly assisted in doing any of these acts of concealment, possession, acquisition or use and projecting? It's the person who is outside of India. He is the person responsible. Now you could transpose that example to even within India. The bribe money might have been paid to somebody having a company in, say, in a different part of the country and unconnected with the government servant. But he is assisting this government servant who has accepted the bribe in projecting tainted money as untainted money. There is a bit of a grey area whether the last phrase and projecting or claiming, if you see, it's concealment, possession, acquisition or use. These 4 words come together and they are separated by commas, and then there is the word use, followed by the word and then the phrase projecting or claiming. So one argument is that mere concealment, possession, acquisition or use is not sufficient to attract the provisions of section 3, unless and until you also project it to be untainted money. So the argument is that laundering, cleaning of this entire tainted money into untainted money is not complete. The offence is not complete till you do not project it or claim it to be untainted money. The argument, of course, of the government and always of the other side has been that any one of these acts, even if you assist in simply concealing it or simply possessing it, it is an act of money laundering. So that is something, I don't think there is a final judgment on that. There are some high court judgments here and there, but finally the point is whether offence is complete when. That's still a grey area. There was a explanation which was added, and that is the explanation which has caused this confusion, because if you see, now the explanation has a nuance. The explanation says for removal of doubts, etc., and then it says the words namely, concealment, possession, acquisition or use, or projecting as untainted property. You immediately see the difference. Sorry, there is no highlight. But here the word comes or, and here the word is and. So the explanation, which was introduced in I think 2018, seems to overstep the main provision. And that is still a debate which is unresolved, notwithstanding Vijay Madanlal Chaudhary. Yeah, I think I'm audible, even without. Now, let's move on to some other significant aspects of this definition. All these acts which it is referring to are in relation to proceeds of crime. So what is proceeds of crime? And that's a very important definition. Can we go to that? Yeah. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity. By any person. As I said, it's a third party. Somebody is kidnapped. The kidnapper wants ransom money. The ransom money is not received by the kidnapper, but it is received by a friend, an acquaintance, or a third party. So even the person who knowingly receives this ransom money at the behest or on the demand of the kidnapper, he also would be covered by the definition. He may not, a defense is not available to him that I was not involved in kidnapping. I just got a call saying that this is the money that is being paid, this is the ransom money. Then the burden shifts on the person who's receiving. There is one more section there, I think section 24. We'll go to that section 24. I mean, we don't need to go it, you can just make a note of it. The general jurisprudence, the law in criminal law jurisprudence, it is there that you are innocent till proved guilty, and therefore the burden of proof is always on the prosecution. However, you know that Parliament can always by law shift the burden. There are many acts which shift the burden. So Narcotics Act, UPA, that is Unlawful Activity of Prevention Act. So similarly, section 24 shifts the burden on the person who is receiving the money to prove that he did not know that these are proceeds of crime. So the person who is receiving the ransom money can say that, well, I thought this was the legitimate money which belongs to somebody. I didn't know that he was a kidnapper. He is my friend. I have had long association with him. I have in the past also received money from him on his behalf. I have accounted for that money and given it to him. So I did not know that this money is part of the ransom money. So the burden will shift on him. But if he fails to discharge the burden, then he gets captured by the definition of any person as a result of a criminal activity relating to a scheduled offense. Relating to, not involved in. There is a plan by a terrorist group to do something in the city, to disrupt it. You need not be a part of that conspiracy. You need not be part of that offense, scheduled offense. You can be independent of that, be involved in money laundering. You will be punished for money laundering, but not for that offense, which is a scheduled offense. If you knowingly received the proceeds of crime, they are relating to the scheduled offense. That's the language uses, relating to, not involved or part of a scheduled offense. So a money launderer, to that extent, is liable, and to that extent, it has been held that money laundering is an independent act. It's an independent offense to that extent. Although there is an umbilical cord with the scheduled offense, and I will come to that a little later, because what is that cord or what is that link between the scheduled offense and money laundering? That's a separate subtopic. But it doesn't lie in the mouth of a person who receives the proceeds of crime knowingly that it relates to a scheduled offense to say, but I am not involved in that main offense. I am not charge sheeted by CBI in the offence of corrupt practice. I am not being charge sheeted or even an FIR against me before the charge sheet is filed. There is no FIR against me accusing me of being a party to the corrupt practice under the Prevention of Corruption Act. It need not be. There's a judgment of our court, in fact, one of the first judgments of the division bench, Radha Mohan Lakotia, which is Justice Khanvilkar's judgment as he was then in our court, which takes this view that in that sense it's an independent offence. So it relates to a scheduled offence or value of such property, or where such property is taken or held outside the country, then the property equivalent in the value held within the country. The second part, which is the bracketed portion, or where such property is outside the country. This has of course been added because of cross-border transactions. So can a person escape the rigors of the law and enjoy the fruits of a scheduled offence just because the money is gone outside of India? Just in the example that I gave you, he received money in a foreign bank account. So can the public servant get away? So initially it was not there. This amendment came much later, and argument obviously for people who want to resist this kind of an action is to say that how can act have an extraterritorial effect? But this is not extraterritorial. It seeks to attach the property within India equal to the proceeds of crime which have gone outside India. So if somebody thinks he is over smart and receives the proceeds of crime outside of India, today he is vulnerable because his property equal to the amount which has gone outside India can be attached in India. So if, let's say, somebody has received 1 crore outside of India, then to the extent of 1 crore value equal to the extent of 1 crore, his property in India will be attached or will attract the provisions of Money Laundering Act. So the net of proceeds of crime are not just confined to the territory of India. If someone thinks he's being over smart and the government can't touch him, that is the reason why they brought this amendment to take care of. Every time there is a new case, Westland, Augusta, or have it what you want to, starting with Bofors, if the government felt that somebody is going to get out of its reach, then the parliament has stepped in. And it's a very smart amendment because it's really not seeking to attach the property outside of India. Because when you want to attach property outside of India, India has to have some kind of a mutual assistance treaty. All countries have got mutual assistance treaty with each other. They are by and large bilateral treaties. So you need, and for criminal matters, criminal law offences, there are different treaties. For tax, there are different treaties. And of course, then you have the overarching Hague Convention, which is for service of summons and other judicial processes. But keeping that Hague Convention aside for the moment, Government of India, if suppose tomorrow wants to extradite somebody, and this is other than extradition, India has got bilateral treaties with almost all the countries that you can think about, UK, UAE, Singapore. Then government has to take care of, take recourse under that, and that's a very tedious process. By the time the process is, the machinery gets activated and you really initiate the proceedings under that mutual assistance, by the time the property would have been whisked away. So if the government starts entering into negotiations or requests Singapore government to go and attach the property, the man, if he gets a whiff of it, he will move the assets from Singapore. So therefore, the government realized that there is going to be a problem in swiftly and quickly. The money moves within matters of seconds. Especially, unless somebody has got a property outside of India, then that becomes a different ballgame altogether. That property then can get attached under the bilateral treaty. But why wait for the tedious? The Parliament thought this is a better way. that if somebody has got property in India, to that extent I will straight away go and reach out and attach the property in India. Now, proceeds of crime in turn takes you to a different part of this act, which is relating to scheduled offence. Now, what is a scheduled offence? There is no rocket science, because it's there in the schedule to the act. Earlier it was very complicated, it was divided into 3 parts. Now everything is almost, although there are parts to part C which relates to cross-border transactions, and essentially that is to attack the Black Money Act. But virtually today it's like reading an index of scheduled offences. All the major offences you will find are covered by the PMLA. So you have IPC, of course, narcotics, that is NDPS, explosive substance, wildlife protection, prevention of corruption act, customs act, and various other, even IP related laws are there, copyright, etc. Sorry, Aditya, go back to that.
Yes.
Environment protection, etc. I think, and then you've got covered SEBI and others by the separate slide, is it?
Yes.
Okay, fine. So SEBI is also part of the scheduled offence. Interestingly, 2 laws which you would have taken for granted will be part of the scheduled offence are not there. Can anyone guess which are those 2 laws which are not part and which you did not find on either of these 2 slides missing, which are very hardcore economic laws? They are Income Tax Act and FEMA, Foreign Exchange Management Act. Given the fact that it is the common agency which is administering both the laws, that is ED, you would think that any offence under FEMA would be automatically covered as part of PMLA, but it's not. And maybe there is a good reason to keep them distinct is because FEMA today has become more of a regulatory law rather than a policing law. So it is more of a facilitator, where RBI acts like a facilitator for foreign exchange transactions. Investments into India are through automatic routes in at least 8 out of 10 sectors. Similarly, investments outside of India are easily permitted or encouraged. You just need to have some net worth. So, to cut the long story short, FEMA is more of a business-oriented or trade-oriented law, and therefore it's not been kept as part of the Money Laundering Act. So if you have not issued shares after receiving the share application money from somebody outside of India within 30 days, you can't be arrested under PMLA. FEMA does not have any provisions of arrest. If you have overexposed yourself and instead of sending out foreign exchange to the extent of 400% of your net worth, you have exceeded that, you will still be admonished, rapped on the knuckle by RBI, penalty, fiscal penalty, etc., etc. But ED and the money laundering can't touch you. Okay. FEMA does not have any provision for arrest. Income tax has, but I don't know when it was last used.
Did FERA?
FERA had it. FERA had it, and then it became a major controversy back in the days. I don't know name it, but if you Google it, the questions were raised in Parliament when a very big industrial house was treated with third-degree methods under FERA, and it became a national issue that, really speaking, this is vendetta. So they then decided to scrap FERA, and they said that if you want to bring in foreign exchange investments, foreign investments, then you can't have FEMA in this avatar. So they changed FERA and brought in FEMA. In fact, there was a provision under old FERA, if I'm not mistaken, section 47, which was declaratory to the extent of saying that if any transaction is entered into in violation of FERA, then the transaction is void. It's void in the eyes of law. So you don't need to go to section 23 of the Contract Act. It would be void under FERA itself. Now that became a big stumbling block and an obstacle for foreign investments. So they removed it, and now we have FEMA. In fact, if you want to understand the distinction between FEMA and FERA, you should look at the judgment of Justice Nariman and Vijay Karya, which is in the context of Section 48 of the Arbitration Act. But he has dealt with it in his usual succinct manner, distinction between FERA and FEMA. So that is aside. So coming back to the scheduled offences, you've seen this. Now, where it gets interesting and intriguing is that proceeds of crime must relate to a scheduled offence. The flip side is, if there is no scheduled offence, there are no proceeds of crime. If there are no proceeds of crime, there is no act of money laundering, offence of money laundering. So the easiest escape route today and the best defense that is available to people who are accused of money laundering, to somehow see that you are freed of the scheduled offence. Now this is the principle which has been recognized, and this is probably the solitary redeeming feature in Vijay Madan Lal Chaudhary's judgment. Vijay Madan Lal Chaudhary says that while it is an independent act or an independent offence under Section 3, but it is founded on the existence of a scheduled offence. So let's take the same example and repeat it again and again. In that public servant example that I gave, that he has been accused of accepting bribe in violation of Section 7 of the Prevention of Corruption Act. He goes to the High Court under 482, Section 482, I don't know what is the new section of that, but old section CRPC 482, or he files for discharge before the magistrate or the special court, before wherever the offence is triable. He goes to the trial court and now seeks a discharge under 239 or 245. In either of these proceedings he succeeds. So either he is discharged or the High Court under 482 quashes the FIR or the charge sheet or whatever that stage of the proceedings it is. Then there is no scheduled offence. The public servant has now succeeded. Or he patiently waits for the trial to be over, and at the end of the trial, maybe 10 years or 5 years, he is acquitted. So in either of these situations, if there is no no scheduled offence, then the person who is accused of money laundering will automatically succeed. I think one of those paragraphs of Vijay Madan Lal Chaudhary, if someone checks it out, it's very clear in black and white. So always the attempt is to somehow get relief in the scheduled case relating to the scheduled offence. Now, these are again, this is part of the definition of proceeds of crime. Let us now see what is the machinery which is available under the Act for initiating the action for money laundering. First and foremost, there is Section 5. Because idea is to immediately attach the proceeds of crime. And proceeds of crime, as I told you, is not necessarily only money or cash equivalent. It could be even a property. A public servant may accept sale of a property in the name of his wife at a throwaway price. So the land then becomes the proceeds of crime. Now, Section 5 provides for powers of the... Sorry, you want to start with search and seizure? Okay, start with search and seizure.
The Section 5 slide is not there.
Okay, why not that? Okay. So, how does the investigation start? It starts by issuing summons, or there is a search, and then there is a seizure of the records that happens or anything else. Seizure I will come to is in two parts, records is one part. So summons, search and seizure. All these are based on the reason to believe that the officer must have. Now, this word reason to believe is both used and abused sufficiently in our country. I mean, you will find judgments both ways, but it's a very subjective term. Having said that, I think if I were to reduce it to the common principles which emanate from both the sides of both the schools of thoughts as to what is the meaning of reason to believe, the bare minimum which all courts have held, that there must be some material available before an officer initiates action of search, seizure or summons. And the words reason to believe are subjective in nature. So there is a distinction which is being drawn between no material and some material. And because it is subjective satisfaction of the officer concerned, the courts are not going to sit in appeal or judgment to decide how much of the material is sufficient for the officer to initiate the action. So the adequacy or sufficiency of material is not subject to judicial review. Courts will not get into that area at all. And the law on summons, challenges to summons is very, very strict. The courts seldom interfere. Seldom means, I would say, in a decimal percentage of the cases the court really interferes. But otherwise they say that summons, at the stage of summons, the reason to believe is a very, very widely used expression. It must be given its full play, and total discretion should be given to the officer concerned to decide what is the basis on which he will launch. Now, interestingly, at the stage of summons, a question which has often arisen is, are you an accused? Does a person who receives the summon, can he call himself that I am now accused of an offence under money laundering? And you know why I am asking that question, because if you are an accused, then there are certain constitutional protections which you are allowed to. Have you heard of Article 20, Sub-Article 3? That article of the Constitution is a protection against testimonial compulsion. Nobody can be compelled to testify himself. What you see in movies, especially the American movies, that you are under arrest and your right of silence, and if you speak is at your own risk, etc., etc. So a warning is administered to the person who is arrested. But at the stage of arrest, you definitely are an accused. At the stage of summons, are you? The answer is no. Our courts have held, right from Nandini Satpathy down to Purpandi and other, including the recent political cases, I don't want to name them, where people were summoned and courts have thrown them out, is to say that you are not an accused at the stage of summon. It's just a fact-finding inquiry. And as a part and parcel of a fact-finding inquiry, it is your obligation to go and give a statement and say the truth. And a statement is a statement on oath. And under some economic laws, that statement is directly admissible as evidence. Those who have studied Evidence Act, and I think it's compulsory to study evidence. Yeah, in law. Its evidence is correct, not in part of your. So, yeah.
There's a presumption that they have.
Yeah. No, I quite understand the role which ILS has, and so for them Evidence Act may not be, Stamp Act may be more important, or Registration Act. Yeah. So under Section 24 of the Evidence Act, any statement made to a police officer is not admissible, or a statement under Section 25 obtained by inducement is not admissible as evidence. That's why a statement recorded under Section 161 of the CRPC, I'm clarifying CRPC so that you don't go and open the new act and you find that I was bluffing. 161 and the new, check the equivalent. It says the same thing, that a state, that's why if someone calls anyone to the police station, God forbid, and makes you write a statement, they don't take your signature. The policeman doesn't take your signature because that statement is not admissible, it's not on oath. Whereas a statement made under section 50 is a statement on oath. It's like an affidavit and you are obliged to speak the truth, and if you do not, it entails criminal consequences. So the law on testimonial compulsion under Article 2 subarticle 20 subarticle 3 does not cover acts such as PMLA. So when you give a statement, you have to be very, very, very careful because it is directly admissible in evidence. You must have read in the papers also that certain Supreme Court granted bail to so and so XYZ because the arrest was based only on the statement of a co-accused, and that is not evidence, and that is because that statement is recorded under section 161 of the CRPC. So if two accused who are arrested, their statements are recorded, you can't use one against the other because that is not evidence. It's not admissible in law. What is not admissible is not evidence. So the statement recorded under 50, however, stands on a very different footing. And that statement being admissible, a person can be arrested or a co-accused can be arrested on the strength of that statement. Similarly for search, of course there is a safeguard, there is a protection involved, and in relation to search, if a person wants the officer to take him to the nearest gazetted officer or the nearest magistrate, I think, then the officer is obliged to take the person before he searches him, that is his person, his body, to the magistrate. But again, in practical life, nobody would have quote unquote the guts to tell an ED officer that, listen, don't touch me, take me to the magistrate, nearest magistrate. That will be the last of that you would have ever heard of that person. But anyway, the law has that safeguard. How many use it? I don't know. I really don't know. So search is there. And seizure, of course, then you can seize the documents and whatever evidence you have. You can seize electronic evidence in the form of laptops, telephones, because everything today is material for the purposes of a case. So your WhatsApp messages, your SMSs, your emails, they constitute in today's world a very, very important part of the investigation.
So do section 5.
Then when we talk of seizure, that is referred to in the context of the seizure during the search which happens. In addition to that, they have a power under section 5 of the Act to provisionally attach the proceeds of crime. So before the proceeds of crime move away and somebody will hide them somewhere or conceal them, the authority has the power, the officer, ED officer has the power to provisionally attach. Now why do we call it provisional attachment? Because he can't wait for the entire formality to be completed. So he will go and immediately attach the property so that the government does not lose control over the proceeds of crime. And it is provisional. Why? Because then the officer under section 5 has to file a complaint to the adjudicating authority. So the officer is a complainant, the one who has seized, and the adjudicating authority is a creature of the statute, albeit an officer of the government. But he is the adjudicating authority who, on the basis of that complaint, will issue you a notice why the provisional attachment should not be confirmed. So just as you have ex parte orders and you go for confirmation, here also post facto you are entitled to a hearing, post facto you are entitled to a representation, and then the adjudicating authority within 180 days, which is 6 months, must either confirm the attachment under section 8 or release the attachment and say it was wrongful. Against the order of the adjudicating authority, you can file an appeal to the tribunal, appellate tribunal, and of course from there the matter can then come to the High Court, etc. Supreme Court is not by way of an appeal. High Court is a limited appeal that you have. like you have in section 100 of CPC, and then of course there is an SLP which is provided. Now, this is one stream of PMLA, where I have told you how the machinery gets triggered, how the proceedings are initiated, starting with search, seizure, etc. Now let's assume that the person whose property is attached does not succeed all the way up to Supreme Court. So he loses before the adjudicating authority, he loses before the tribunal, he loses before the High Court, and of course the Supreme Court. Then what happens to that property? It's attached. And then the question obviously which we will raise is, what happens to that property? That property which is attached stays parked till the scheduled offence is tried. Which is the second stream of the proceedings under PMLA. So proceedings under PMLA are divided into two parts, and they are not watertight, they are not in two silos, they are interdependent. The first is a more of a civil, if I may just use a very loose expression just for the sake of better understanding. First is the civil part of it, that is search, seizure and attachment, provisional attachment and final attachment. The other is which can get triggered with an arrest, and then from it, there may be an arrest, it may not be, there may not be an arrest. It's not mandatory for every person to be arrested under by the ED under FEMA. Unless you are politically important, then you will be. But that arrest starts with section 45. Now 45, for those who have academic interest, will like to read a judgment in Nikesh Tarachand Shah, which is again Justice Nariman's judgment. Just look at section 45. Section 45 deals with grant of bail under PMLA. It has two conditions which the judge granting the bail must be satisfied. One, that the public prosecutor has been given an opportunity to oppose the bail application, which is a very simple, plain vanilla requirement. Somebody may say, why is it there? It's axiomatic, it's a requirement of principle of natural justice. Why did the parliament have to so painfully put it down and say the public prosecutor must be given an opportunity to be heard? He will be heard in any case. But the second one is not as innocuous as the first one. And the second one says, and where the public or prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offence and he is not likely to commit any offence while on bail. These are not just very simple words, and please don't mistake them to be just another condition which is provided for in a matter relating to bail. I'll digress a bit, because once again, under the criminal jurisprudence that has evolved in this country over a period of time, and I'm also talking about pre-partition days, is that personal liberty has always been rated as the highest form of liberty, personal liberty. So when you are dealing with bail matters, and the Supreme Court has even reiterated this last week or last month, both, that bail is the rule and jail is an exception. When a person is arrested, unless of course the offence is a heinous one, like something which attracts life imprisonment or death or capital punishment, leaving aside those heinous offences, normally the court will grant bail, and that's the general rule, the thumb rule. And what are the considerations which normally weigh in the mind of a judge or a magistrate when he grants bail? Three things. One, is the person going to flee from justice? That is he going to abscond and not be available for trial? Two, is he going to tamper with evidence? So if I release him on bail, he will go and destroy papers, he will, throw the telephone, mobile phone in the sea. Is he going to tamper with evidence? And the third, is he going to influence witnesses? These are the three classical tests. Just like in civil matters, when you go for Order 31, Rule 1, Order 39, Rule 1 for injunction, the three famous tests of an American Sanamite: prima facie case, irreparable loss, balance of convenience. Similarly, on the criminal side, for bail, you have these three conditions. So, if the judge is satisfied, the magistrate is satisfied that the accused is not going to tamper with evidence, not influence witnesses, and is not going to flee from trial, then he will grant him bail. In this case, it's not the magistrate. Under PMLA, all cases go to the special judge, and the special judge is of the rank of a sessions court, not a magistrate. So all PMLA cases go to the sessions court, special judge. So he has to be satisfied. But look at what the Parliament has said here. And again, this is not a sui generis provision. It's such a provision you will find under many other laws, including UAPA, or the I think also POSCO has that. I'm not very sure. I think POSCO has it, but then NDPS has got it. UPA has got it. That not only the judge has to be convinced about the three classical tests that I mentioned, but the judge has to go a step further and be satisfied that he is not guilty of such an offence. That means he is likely to be released at the end of the trial. Prima facie case the judge has to see. And that he is not likely to commit this offence again. Under the general category, if a bail is granted, if the person is again commits an offence, that's treated as a separate offence and he will be re-arrested for that offence. But that doesn't become the consideration for the magistrate to grant him bail to see is he likely to commit another offence. And the judge doesn't go into the merits of the case, not even the prima facie merits of the case. The magistrate does not get into those aspects at all. But in this case, he has to look at the prima facie view and take the bail. If you look at a very recent judgment of our court, Justice Pitle's judgment in Sanjay Chabria, where yours truly appeared and got bashed and got thrown out, he has dealt with this to say that 45 twin conditions, that we did not satisfy the first condition of believing that we are not guilty of money laundering. Now, in the judgment which you see at the bottom of the slide, Nikesh Tarachand Shah, Justice Nariman struck down section 45. He was a pro-liberty person, so he struck down. And there was very, very good sound reasoning that he gave. Because, curiously, the person who was guilty of a scheduled offence would not be saddled with these two conditions. So, in the examples that we have been discussing through the evening, the public servant who receives the bribe, he would be governed by the general law of general criminal law. So he would get bail if in his case the magistrate was satisfied that he is not going to influence witnesses, tamper with evidence, or he is not going to run away. So I'll grant him bail. But the person who is accused of money laundering, because the one who harbored the bribe money on behalf of this public servant, that person will have to go through a stricter test. And the joke then would become that this public servant would get bail, but the man who had received the bribe money on his behalf would be languishing inside. So Justice Nariman said there has to be parity between the two. And taking the principle from Navjot Singh Sandhu's case, that a parliamentary act can be struck down as manifestly arbitrary under Article 14. He held Section 45 to be manifestly arbitrary and struck it down. Now what the Parliament did was, do you have the amendment here? Yeah, okay. You see the bracket in the first part with footnote 2, under this act. Prior to this, the language was, no person accused of an offence where the imprisonment was beyond 2 years or 3 years. Sorry?
Part of the schedule.
Part A of the schedule. Part A of the scheduled offence. So he looked at, Justice Naraman looked at schedule, part A of the schedule, and then compared those offences with the Money Laundering Act and said, such a person who is guilty of committing the scheduled offence can get away, but the man accused under Section 3 cannot get away. So he struck it down. What the Parliament decided to do is remove those words and substitute it for the words accused of an offence under this Act. This Act means Money Laundering Act. And unfortunately, in Vijay Madan Lal Chaudhary, a 3-judge bench, Nikesh Tarachan was 2-judge. 3-judge bench in Vijay Madan Lal Chaudhary said that the amendment made in 2018 by substituting with the words under this act has cured the defect which was pointed out in Nikesh Tarachan. How many of you are familiar with curing of a defect and what is the legal expression word called for that? The legal word called for that is Validation Act. So if a court strikes down a law, then the Parliament or the Legislative Assembly, as the case may be, can revisit the issue by removing the bad portion of the Act and substituting with a different language and curing the defect which the court pointed out. Such acts are called Validation Acts. And there is, if you read Vijay Madan Lal Chaudhary, it gives you reference to the earlier cases, Prithvi Cotton and a whole host of cases, that Parliament has the power, the legislative competence to remove the basis, the bad portion of the of the law, which was struck down in the by the court and substitute with a new. So that law is very clear. There is no quarrel with the proposition that Parliament has the power, it's the supreme power to remove the defect on the basis of which it was struck down and make an amendment to the law. Question is that does this really remove the defect? By substituting the words under this act, have you overcome the fallacy pointed out by Justice Naraman when he said that you are imposing more rigorous conditions on a person who is accused under Section 3 as opposed to a person who is guilty or accused of an offence which is a scheduled offence? That parity you have not removed it, because now you have in fact tightened it. Under this act means under Section 3. What is Section 3? Offence of money laundering. What is offence of money laundering? That is, you are concealing, using, etc. and projecting as untainted money, proceeds of crime, that is, relating to a scheduled offence. So a person who is accused under Section 3 still has to pass through these two tests, the second one being the real draconian one. Whereas the person who is accused of let's say somebody who is accused of forgery, and as part of the forgery he has received some proceeds of crime. Somebody has helped you in forging a valuable document. It could be a will, it could be a security, it could be conveyance deed. He has forged it, and for forging it, he has received some consideration. So the person who has acted on his behalf to conceal that and project it as untainted money, he will still have to satisfy these two tests, but the person who is guilty of forgery may get away on the basis of those three simple tests, whether he is going to flee, whether he is going to tamper, or whether he is going to influence witnesses. So this amendment has not really cured or overcome the fallacy in the law, the manifest arbitrariness which was pointed out in Nikesh Tarachan by this amendment of 2018. Having said, we are today faced with a judgment. It is binding on all of us. Until such time it is reviewed, and there is a review which is already, I believe, yesterday bar and the bench I think reported that the arguments are continuing or they have been reserved by bench of Justice Sanjeev Khanna. So, and again, I'm not sure what is the scope of review. Like someone to inform me that this portion of Vijay Madan Lal, which deals with section 45, is not the subject matter of review. Some other portions of the judgment dealing with search, seizure, summons, they are part of the review. So this is unfortunately probably will remain the law of the land until such time Vijay Madan Lal Chaudhary is overturned by a larger bench. So this is an important part of FEMA today, and this is why today you find the critics really saying that PMLA is abused or misused, largely because of the stringent conditions that are required to be met in getting a bail under section 45. Aditya has been very helpful in putting down all recent judgments where Supreme Court has granted bail, starting with Hemant Soren, Prem Prakash, Manish Sisodia, Kavita, and all of these cases. But let me tell you, all these judgments are an alternative route to section 45. In all these judgments, the common thread is that delay in trial. Because there was a delay in trial under the PMLA, section 44 says the trial can be either combined with the scheduled offence trial or continue on its own. ED has the right to ask for combining the trial, joint trial. So they have been all released on bail because of delay in the trial, not because section 45 has been read down by any of these judgments, except in Arvind Kejriwal, where Justice Sanjeev Khanna towards the end has left that question of law open and granted interim bail to Arvind Kejriwal. He has left that question open as to really speaking what it is. In fact, there was a very good judgment, a pro-personal liberty judgment, which was in the case of Pankaj Bansal on a slightly different point. And Pankaj Bansal said that the grounds for arrest have to be furnished to the person who is being arrested. And ED had taken the view that oral communication of the grounds is sufficient. Supreme Court said nothing of the kind. The grounds have to be communicated in writing. Unfortunately, in a subsequent case, a coordinate bench of the Supreme Court picked one word from Pankaj Bansal and said the word henceforth used is to be applied prospectively and not retrospectively. That means all those who are arrested in the past without communicating the grounds of arrest will stay inside. They will not get the benefit of Pankaj Bansal. But those who are going to be arrested from tomorrow, they will be entitled to receive the grounds of arrest. In other words, nobody would get the benefit of the law laid down in Pankaj Bansal. Because all those who are arrested will remain inside. Judgment is not retrospective. You know that every judgment of the Supreme Court, said, unsaid, is retrospective in nature. Why? Can anyone answer why? Because every judgment by the Supreme Court is declaratory of the law as it exists. It exists from the beginning. Today, if the Supreme Court is deciding a matter under Section 2D of the Contract Act as to what constitutes a consideration, it declares the law which will apply from the date the Contract Act was made or enacted. It is declaratory in nature of the law, so it relates back. Unless the Supreme Court says on its own consciously that it has prospective application. And this debate again you would have seen in the recent judgment of 9 judges where the question was whether the state governments have the power to collect royalty in addition to the tax mining cases. And there was a debate whether states should do it prospectively or retrospectively. The Supreme Court said we have made it very clear, we are not saying it is prospective, it will apply from the time the law existed. So the general rule is all judgments of the Supreme Court are retrospective in nature because they are declaratory, Article 141. And unless the court makes it, but surprisingly, even though it was a case of personal liberty, Pankaj Bansal, the Supreme Court in a subsequent judgment said the word henceforth meant that the court in Pankaj Bansal decided the law to apply prospectively. So that's why continues to be a media catching provision. Anytime anybody is arrested by ED, really speaking, that makes the life very difficult for the person.
And this was discussed in Praveen Kejriwal also, section 19 reasons to be.
Correct. And therefore they have left that question of law open to be decided. But till such time, it will prevail. Okay, you got Pankaj Bansal on this. Yeah. Which is the other one?
So, which one are you looking for?
No, fine. I got Pankaj. Yes, you covered this. So now, after arrest, what's the next step? The next step is that the ED has to file a complaint. And the complaint has to be filed before the special judge, which is a sessions judge. Why do we call them special judge? Because they are notified under PMLA as courts for conducting trials under PMLA. So therefore we call them special judge. The special judge then tries the case like any other criminal act on the basis of a complaint filed by the ED. One important part that you should remember, and that when you read PMLA it features nowhere, is that prior to a complaint being filed in court, there is a document which the ED makes or generates, and it's called ECIR. ECIR, the closest example that I can give you is like an FIR. But the courts have held it to be not an FIR. Though I'm giving you the example, please don't mistake it, misunderstand. It was just for the sake of communication. Courts have held ECIR is not an FIR. There is no provision in PMLA for filing of an ECIR. They said it's an internal document which is made for their internal purposes and not for the purposes of filing it in court. FIR, as you know, even after the police registers it, it is lodged with the jurisdictional magistrate's court. I don't know how many of you know that any person accused can get a copy of the FIR once it is filed, registered by the police, because they are supposed to mandatorily file a copy of the FIR in the magistrate's court. How many get it? That's a different problem altogether. That's a menace in our country because you won't get anything as a matter of right. But the law provides for it. So that's a distinction. ECIR is not filed anywhere. It's an internal document. And that's why a large number of petitions have been dismissed by the courts, where petitions were filed for a mandamus to say, give me a copy of the ECIR, and that has been rejected. So we come back to complaint. Complaint, the trial continues. Under section 44, as I said, ED can say that let there be a joint trial for the scheduled offence and for this. The problem arises if the scheduled offence is not before the sessions court. So all CBI matters, prevention of corruption matters, terrorist act matters, drug matters, they all in any case go to the sessions court. But other than that, let's take a simple example of theft or robbery, kidnapping, or for that matter, forgery. They may go to the jurisdictional magistrate, and PMLA is here in sessions court. Now in that case, the PMLA trial has to await the outcome of the scheduled offence trial. So conceive of a situation where the trial for forgery is being conducted in the Esplanade Court next to VT station, and the PMLA trial is around the corner here in the Sessions Court, and Magistrates Court takes 10 years for the trial to be completed. And after that, you can imagine there will be an appeal under 378, then there will be further appeal, etc., etc. Now, what is the significance of this? I'm not giving you these statistics about the delays that occur in a trial only because that's a very fashionable way of criticizing the courts. No. Go back and think of the first stream of attachment and that civil nature proceeding. The property which is attached and which attachment has attained finality and you have lost all over right until Supreme Court, that continues to remain under attachment till the trial of the scheduled offence is complete. If the trial goes against the accused and then he is convicted and imprisoned, then of course the proceeds of crime which are attached get forfeited by the government or confiscated by the government. They become the property of the government. And then the government will sell it, realize the money and of course appropriate that money.
Does PMLA have priority?
I'm coming to that. That's a very vexed issue, and that's an issue which really today is pending in the Supreme Court, especially in the context of IBC, especially in the context of SARFAESI and the lenders' rights. Secured creditors, secured lenders, what are their rights? So just to complete the loop on this, if the person succeeds in the trial, then of course the property is released and handed back to him. There is a very important provision which very few know, and that there's not enough law which is developed on it, but it should be used more often. Is that if the property which is attached, somebody says that it actually belongs to me and it has been, I'm an innocent third party who is, let's say ED attaches the property of a person who is in the process of having completed a sale transaction but has not registered the document, or the society has not changed the share certificate but has received the full consideration. Now, in such an example, the innocent party can go to the court, that is the sessions court, and say that I am the innocent party who is the real owner of this property and produce evidence. So you have a side trial, conduct a side trial, and the sessions court has the power to release the property immediately. Of course, you can't take the advantage of a Benami property because then that is a bar which is hit by Section 3. Oh, thanks. So that, for those who are looking to protect innocent clients who have acquired the property without notice of the taint attached to it, then they can have this recourse and they need not wait for the end of the trial, which is the end of the 10 years. With that, I will move on to Meer's question of whether PMLA prevails over any other law. Now, in the example that we gave, let's assume that the property which was proceeds of crime, the person has gone and raised funds from the bank against by collateralizing that property or offering that as a security. And the bank innocently accepts the mortgage, becomes the mortgagee, lends funds against that property. What does the bank do with that? So, SARFAESI and the debt recovery laws do not provide for any relief to the bank and financial institution. However, the IBC does, and that is Section 32A. And and of course, Aditya is very helpfully on the top of the slide put in the judgment where I give you example of one where I lost. This is Pitle, but this is a judgment where we succeeded. This is Shiv Charan versus Adjudicating Authority, where the division bench of our court, Justice Kulabawala and Justice Sundaresh, they held that the attachment by the ED after the approval of the resolution plan was bad and had to be set aside and struck down this, following 32A and Manish Kumar. In this case, what had happened was the ED had already attached it pre-CIR. Pre-CIR. It got admitted, the corporate debtor went into CIRP. The resolution plan was approved by the lenders. The resolution applicant took over, and the NCLT in its plan approval order held that the attachment by ED will have to will stand vacated under section 32A. ED refused to comply with the NCLT order, saying that who is NCLT and how dare they give directions that the attachment is vacated, and refused to lift the attachment. So we had it is an offence of black money, and that would automatically attract the provisions of PMLA. So tomorrow, if it is discovered that you had an, how many of you were familiar with Panama leaks or prior to that other WikiLeaks leaks, etc. That many people in India were said to have foreign accounts which were undisclosed in the income tax. In income tax, there is an obligation to disclose foreign assets. There is a form called FA, Foreign Assets Disclosure. So every Indian citizen or resident must declare that he has no foreign assets. Now, if subsequently it is discovered that that declaration was false and there is a foreign asset, then to that extent the Black Money Act gets attracted. There is a tax, there is a 3 times penalty, there is an interest, there is a prosecution. But separately, the money equivalent which was in that foreign account, that can be attached here under section 3 as proceeds of crime. So that's the black money, in fact, supports PMLA. So that's the interplay between them. With that, I think I've covered all the important aspects of PMLA. If there's any question, happy to answer.
So you mentioned this complaint, but I think there are cases where people are taken arrested.
Mention about filing complaint about by ED, but I think Justice Abhay Oka's May 17 judgment, he has held that people are arrested before the complaint is filed, then they can get bail.
Of course.
Right?
Yeah.
Then the 45 is not.
No. 45 is attracted at the moment you are arrested. Complaint and arrest has nothing to do with each other. For example, in the normal criminal law, the moment an FIR is registered, the person can be arrested. Whereas the charge sheet is filed much later. So charge sheet and complaint, you just put that parallel example. So arrest has nothing to do with complaint. Arrest may be a precursor to the complaint. Okay. And complaint is the one which sets the criminal law machinery into motion.
So even that Justice Abhay Oka's judgment in that case also 45 will be?
Yes, will be active.
Yes, thank you for this talk. Very informative and interesting. About the proceeds of crime, is it correct to say if you are in that sense an innocent person who wasn't really aware that they're proceeds of crime, if it's taken for consideration, like your example of, a transaction that's just maybe not formally completed but otherwise completed, then you are out of the net. But maybe if it's a gift or something not for adequate consideration, then does that continue being proceeds of crime? Even though you may not really have been involved or been knowledged or have been in knowledge.
As I said, the burden is on you. Section 24 will be burden will be on the recipient. That I got this gift out of natural love and affection, which otherwise meets all the ingredients of a gift, etc., etc. Section 25 of the Contract Act permits this to be without consideration transaction. You show all of that evidence, and then relationship, the cause for the gift. You can say during marriage the gift was given or what. So there has to be a plausible explanation being given.
Right, or otherwise, so in that sense, I'll still have to show some intention for even the attachment of the property.
For getting the attachment released, vacated, yes. You have to make out a case on merits, on facts.
Love and affection from the launderer is not.
I mean, don't take that example too far, because otherwise many lawyers have asked me this question. When we get fees from persons accused of money laundering, are those proceeds of crime? So there again, it is because of the services that you render, you are getting a bona fide consideration for the services. Yeah.
So if you have, for example, sold valuable property,
Yeah.
or you sold land,
Yeah.
and you have got money which you did not know was coming from an entity who has,
Yeah.
doing the stuff.
Correct.
Then ED gives you a notice saying that you have received money from proceeds of crime and give the money back.
Yeah.
So property is already got transferred.
Correct.
So is it a defense
No,
to say
it's a good defense because the property is available. If they are proceeds of crime, they will go and attach the property.
To the value of the extent of the proceeds.
So the innocent seller, he will not get saddled with this guys.
Purchase the receipt.
No, the innocent seller.
Yeah. I mean, we had one case where bank fraud, typical bank fraud. So all cases of bank fraud these days get hit under section 420, the cheating cases. So people divert bank loans, don't repay, declared NPA, etc. I had a case where one celebrity in Bollywood had received some money for inaugurating a show. So he went to cut a ribbon at some showrooms of that company which was accused of. And ED came to him and attached his property worth that much money that he had received. So then he had to show that, no, I went there as a celebrity, these are photographs, this is an event, I didn't know that. How the hell do I know? Because the event was held in 2012, loans were sanctioned or facilities were given in 2010, NPA he was declared in 2017. So in between, if I received this money, it was not proceeds of crime. Yeah.
Anybody else?
Just one more question. I noticed that the schedule of offences also includes confidentiality and privacy. Any particular reason why something like that? Under Information Technology Act, it was written offences related to confidentiality and privacy. Why would that be in the schedule of offences?
So, I mean, quite a few of these offences.
I just didn't really
Yeah,
get
so
that.
under the information technology, I think they wanted to protect some of the acts, and therefore they have put in there that if someone breaches that, so typical cases where there's data, stealing of data. So quite a few, like one of the cases that I was involved in is the employee concerned had not only been poached but had been planted as a Trojan horse in the company and was stealing data and passing on through pen drive, through other things. So that is a breach of the information
Because
technology.
that data could be very important.
Yeah, customer data and other details.
Proceeds of crime.
Yeah. Yeah. Okay.
Anybody else? Thank you very much, Vikram. As a token of our gratitude and gratefulness, let us give you a small plant.